Welcome to the Child and Dependent Adult Abuse and Neglect Training. In 2004, approximately 378,301 cases of abuse and neglect involving 713,391 children who were referred for investigation in California. Unfortunately, there are many detrimental effects of child abuse and neglect. For instance, children who are exposed to violence, such as child abuse, are at greater risk for depression, post-traumatic stress disorder or PTSD, increased alcohol and/or drug abuse, and lower academic achievement. In addition, children with disabilities are estimated to be abused at 4 to 10 times the rate of those in the general population. This is why it is so important that individuals who are working with clients with autism and other special needs are aware of the definitions and signs of abuse. However, it is also more tricky to identify the signs of abuse or neglect in a child with disabilities, because oftentimes the emotional and behavioral signs of abuse in children with disabilities may differ from those of typical children. For example, as you will see throughout this training, some common characteristics of autism are similar to signs of abuse or neglect. Therefore, with the special needs population, it may be difficult to determine if the behavior observed is a symptom of their disability or of a bigger problem, such as abuse or neglect. Now let's go over the outline for this training. First, we will review the types and signs of child abuse and neglect. Then we will review situations that are not considered abuse or neglect. We will review what elder and dependent adult abuse and neglect is. We will discuss the zero tolerance policy and consequences for not following that policy. We will go over your responsibility to protect clients from abuse and neglect. Furthermore, we will discuss the concepts of duty to warn and duty to protect. We will also review that technicians are mandated reporters and go over the requirements for mandated reporters. Finally, this training will cover the process for reporting abuse and neglect, as well as the consequences if mandated reporters do not report. This training is going to review the types of abuse as described in California law. However, each state or country may have different laws and definitions of what constitutes abuse and neglect, so you should refer to specific state laws for this information in order to ensure that you are in compliance if not residing in California. As for the types of abuse as defined in the California Penal Code, Section 11164-11174.4, this includes sexual abuse, neglect, physical abuse, and emotional abuse. Now we will review each of these types of abuse, as well as the signs that may be demonstrated by either the child or the parent. The first type of abuse we will cover is sexual abuse. Sexual abuse may be broken into the two categories of sexual assault and sexual exploitation. Sexual assault includes rape, statutory rape, that is, when the offender is 21 years or older and the victim is under 16 years of age. Rape in concert, that is, gang rape, incest, sodomy, and lewd or lascivious acts, that is, indecent or lustful acts upon a child under 14, or with a 14 or 15-year-old when the offender is at least 10 years older. Sexual assault also includes oral copulation or intercourse, sexual penetration of genitals, child molestation, intentional touching of the genitals or intimate parts or clothing covering them, and masturbating in the presence of a child. In addition, sexual exploitation refers to any of the following: conduct involving matter depicting a minor engaged in obscene acts, including preparing, selling, or distributing obscene matter that depicts minors, or employing a minor to perform obscene acts. In addition, sexual exploitation refers to any of the following: promoting, aiding, assisting, employing, using, persuading, inducing, coercing, or permitting a child to engage in prostitution, live performances involving obscene sexual conduct, or modeling for film, photography, negatives, slides, drawing, paintings, or other pictorial depictions involving obscene sexual conduct, as well as depicting a child in or knowingly developing, duplicating, printing, or exchanging any film, photograph, videotape, negative, or slide involving a child engaged in obscene sexual conduct. You should consider the possibility of sexual abuse when the child indirectly or directly reports sexual activities to a friend, classmate, teacher, or other trusted adult, wears torn, stained, or bloody underclothing, has an injury or disease, such as a sexually transmitted disease or STD, which is unusual for his or her age, or when a young girl is pregnant, along with these other indicators. You may also further consider the possibility that a child has been a victim of sexual abuse when the child has detailed, age-inappropriate knowledge of sexual behavior, inappropriate or aggressive sexual behavior with peers or toys, compulsive indiscreet masturbation, or excessive curiosity about sexual matters. With regard to the signs demonstrated by the caregiver, you may consider the possibility that a child has been the victim of sexual abuse when the caregiver is unduly protective of the child or severely limits the child's contact with other children, especially of the opposite sex, is secretive or isolated, or is jealous or controlling with family members. Now let's stop for a minute for our first quiz question. Question number 1 is, which are types of sexual exploitation? Is it A, conduct or activities related to pornography depicting a minor engaged in obscene acts? B, preparing, selling, or distributing obscene matter that depicts minors? C, employing a minor to perform obscene acts, prostitution? Or D, all of the above? Correct. The answer is D. All of the above are types of sexual exploitation. Now we will review the definition and signs of neglect. Neglect can be defined as negligent treatment or maltreatment of a child by a person responsible for the child's welfare, indicating harm or threatened harm to the child's health or welfare. Neglect can be categorized as severe neglect and as general neglect. First, we will define severe neglect. Severe neglect is defined as the failure of a parent or caretaker to protect the child from severe malnutrition or medically diagnosed non-organic failure to thrive. It involves willfully causing or permitting the child or the child's health to be endangered, including intentional failure by a parent or caregiver to provide adequate food, clothing, shelter, or medical care. The second type of neglect is called general neglect. This can be defined as the negligent failure of a parent or caregiver to provide adequate food, clothing, shelter, medical care, or supervision where no physical injury to the child has occurred. An example of general neglect is when a parent leaves a young child unsupervised after school. Children left in these circumstances may also be particularly vulnerable to accidents, injuries, or crime. However, there are some situations that alone are not considered neglect. For example, a child receiving treatment by spiritual means or a child not receiving specified medical treatment for religious reasons is not, for that reason alone, considered neglect. Moreover, an informed and appropriate medical decision made by parents or guardians after consultation with a physician or physicians who have examined the child does not constitute neglect. Now let's review the signs of neglect. You may consider the possibility that a child has been neglected when the child is frequently absent from school. However, with children with autism and other special needs, they may miss school for other medical and behavioral reasons. Other signs are if the child begs or steals food or money, lacks needed medical or dental care, immunizations, or glasses, is consistently dirty and has severe body odor, lacks sufficient clothing for the weather, abuses alcohol or other drugs, states that there is no one at home to provide care, In addition to those signs in the child, you may consider the possibility of physical abuse when the caregiver appears to be indifferent to the child, seems apathetic or depressed, behaves irrationally or in a bizarre manner, or is abusing alcohol or other drugs. Sometimes, we also work with clients who have parents or caregivers with documented mental or developmental disabilities. However, even in these cases, the parent or caregiver must provide appropriate care to the client that is not neglectful. Okay, here is quiz question number 2. Which of the following may be signs of neglect? A. Child has unexplained burns, bites, bruises, broken bones, or black eyes. B. Child is consistently dirty and has severe body odor. C. Child is wearing sufficient clothing for the weather. Or D. Child shows excessive curiosity about sexual matters. Yes, the answer is B. A sign of neglect is when the child is consistently dirty and has severe body odor. So now let's move on to reviewing the third type of abuse, which is physical abuse. The definition of physical abuse is any non-accidental act that results in physical injury to the child. Examples include intentional or deliberate assault, such as burning, biting, or cutting the child. Physical abuse includes, but is not limited to, willful cruelty or unjustifiable punishment, such as willfully inflicting unjustifiable physical pain or mental suffering, or willfully causing or permitting the child to be endangered. An example of this type of physical abuse might be when a child misbehaves and then a caretaker deliberately punches, shakes, or chokes the child. Physical abuse also includes unlawful corporal punishment, such as willfully inflicting cruel or inhuman corporal, that is physical, punishment, or injury resulting in a traumatic condition, that is a wound. An example of this type of physical abuse might be when a child misbehaves and then a caretaker deliberately beats the child with a belt, leaving multiple welt marks on his back. Now let's go over some of the signs of physical abuse that you may observe in a child who has been abused. You may consider the possibility of physical abuse when the child has unexplained burns, bites, bruises, broken bones, or black eyes, has fading bruises or other marks noticeable after an absence from school, seems frightened of the parents and protests or cries when it is time to go home, shrinks at the approach of adults, reports injury by a parent or another adult caregiver, or abuses animals or pets. In addition to those signs in the child, one may consider the possibility of physical abuse when the parent or other adult caregiver offers conflicting, unconvincing, or no explanation for the child's injury, or provides an explanation that is not consistent with the injury, describes the child as evil or in some other very negative way, uses harsh physical discipline with the child, has a history of abuse as a child, has a history of abusing animals or pets. All right, we are ready for our third quiz question. Which is considered physical abuse under California law? Is it A, any accidental act that results in physical injury to the child? B, any non-accidental act that results in mental injury to the child? C, any non-accidental act that results in physical injury to the child? Or D, none of the above? That's right, the answer is C. Any non-accidental act that results in physical injury to the child. Now we will review the definition and signs of emotional abuse. Emotional abuse may be divided into two categories, one being emotional abuse and the other being emotional deprivation. First, let's go over the definition of emotional abuse, which involves inflicting mental suffering upon a child or endangering a child's emotional well-being. Emotional abuse may include the following: verbal assault, for example, belittling, screaming, threats, blaming, or sarcasm; unpredictable responses, continual negative mood, constant family discord, or chronically communicating conflicting messages. Another type of emotional abuse is called emotional deprivation. This includes the parent or caregiver withholding affection in the form of touch, smiles, and sound. So now let's review the signs of emotional abuse. This section is tricky because some of these signs are also characteristics of autism. Therefore, you must carefully consider all the factors involved when making the judgment to report. In general, you should consider the possibility that a child has been emotionally abused when the child is clingy and forms indiscriminate attachments, exhibits exaggerated fearfulness, displays signs of emotional turmoil, or unwittingly makes comments such as, "Mommy always tells me I'm bad." The following signs of emotional abuse are also characteristics or symptoms of autism, so they must be considered carefully. Examples of these signs are when the child is withdrawn, depressed, and apathetic, is overly rigid, suffers from sleep, speech, or eating disorders, suffers from bedwetting and fecal soiling, pays inordinate attention to details, and acts out and is considered a behavior problem, for example, bullying and cursing. Clients with autism often act out and may have behavior problems. However, bullying and cursing are not typically examples of a client with autism's behavioral problems. In addition, you should consider the possibility of emotional abuse when the parent or caregiver places demands on the child that are based on unreasonable or impossible expectations or without consideration of the child's developmental capacity. The child is used as a battleground for marital conflicts. The child is used to satisfy the parent's own ego needs. The child is objectified, called it, or the child is a witness to domestic violence. All right, now it's time for quiz question number 4. Which is a type of emotional abuse? A. The parent verbally assaults, for example, belittles, screams, threatens, blames, or is sarcastic to the child. B. The parent is in a continual positive mood. C. The parent withholds affection, such as touch, smiles, and sound. Or D. The parent leaves the child without any provision for support. You got it. The answer is A. Parent verbally assaults, for example, belittles, screams, threatens, blames, or is sarcastic with the child. So now let's review situations that are actually not abuse. First, it is not considered abuse for two children to be fighting with each other. It is also not abuse for a parent to use reasonable force with a child. Furthermore, corporal punishment, such as spanking, is not considered abuse on its own. Giving a child medical treatment is not considered abuse. Voluntary sexual activity between children under age 14 is not considered abuse. Pregnancy of a minor is also not considered abuse. Other situations that are not considered abuse are when an adult discloses past abuse that occurred when he or she was a child. Also, if a mother is abusing substances and has a positive toxicology screen at birth, this does not automatically count as abuse. Also, a child dying of sudden infant death syndrome, or SIDS, is not considered abuse by the parents. Furthermore, it is not considered abuse if reasonable force is used by school personnel: 1. To stop a disturbance threatening physical injury to people or damage to property. 2. For self-defense. Or 3. To obtain possession of weapons or other dangerous objects within the control of the child. Finally, injury caused by reasonable force of a peace officer acting within scope of employment is not considered abuse. So let's move on to quiz question number 5. Which of the following situations could be considered abuse? Is it A. An 8-year-old child punches his 7-year-old sibling in order to get his toy back? B. A father punches his 7-year-old child in the face for spilling milk? C. A father spanks his 7-year-old child once on the bottom for lying? Or D, a mother forces her 4-year-old child to take prescribed medicine while he screams no and resists? You got it. The answer is B. A father punches his 7-year-old child in the face for spilling his milk. Okay, so let's move on to discuss another type of abuse, which is elder and dependent adult abuse. The California Welfare and Institutions Code 15600 to 15675 describes who are mandated reporters of elder and dependent adult abuse, as well as the definition of this type of abuse. For elder and dependent adult abuse, any person who has assumed responsibility for the care or custody of an adult client is a mandated reporter. This may include administrators, supervisors, and any licensed staff of a facility that provides care or services for adult clients. Please note, this list of mandated reporters is different than the list of mandated reporters for child abuse because it includes administrators who may not be directly involved. With regard to elder and dependent adult abuse, a mandated reporter shall make a report in the following situations. He or she has observed or has knowledge of any incident that reasonably appears to be physical abuse, abandonment, abduction, isolation, financial abuse, or neglect of an adult client. Or he or she is told by an adult client that he or she has experienced adult abuse. Or he or she reasonably suspects the existence of adult abuse. All right, here is quiz question number 6. Which of the following are mandated reporters of elder abuse? A. Administrators of adult care facilities. B. Supervisors of adult care facilities. C. Licensed staff of adult care facilities. Or D. All of the above. Yes, you got it. The correct answer is D. All of the above are considered mandated reporters of elder abuse. So now that we understand the different types of abuse or neglect, let's review a standard zero-tolerance policy for abuse and neglect. Nothing is more important to an organization than the health, safety, and security of its clients and employees. Therefore, most organizations have adopted a zero-tolerance policy related to client abuse or neglect. Basically, this policy states that client abuse by employees will not be tolerated. Please review the zero-tolerance policy that has been provided as a resource for this training, if applicable. The consequences for an employee failing to follow the zero-tolerance policy is that any employee found to have engaged in abuse against a client will be subject to severe discipline, up to and including immediate termination of employment and/or prosecution to the fullest extent of the law. Technicians have a responsibility to protect clients from abuse and neglect. Specifically, the following are some steps that you may take if you become aware of abuse or neglect. First, take immediate action to stop the abuse from occurring to the extent permitted by law. Next, ensure the health and safety of the affected client and all other clients receiving service. Then, call your supervisor to report the incident and get further instructions. Finally, report the incident to the appropriate authorities in accordance with state-mandated reporter laws. Now let's review the concepts of duty to warn and duty to protect. In general, if you become aware that the client presents a serious danger of violence to another person, the Tarasoff rule allows therapists to break client confidentiality in order to protect individuals from harm. The duty to warn refers to the original requirement that therapists must verbally tell an intended victim that there is a foreseeable danger of violence. Due to concerns from the psychotherapeutic professionals, this was subsequently updated to the duty to protect, which is the requirement that the therapists must determine if there is a serious threat of homicide or suicide and are obligated to use reasonable care to protect an intended victim against danger. This may entail warning the victim, notifying the police, or other reasonably necessary steps to ensure individuals remain safe. For example, medication, hospitalization, psychotherapy, etc. Furthermore, California Civil Code 43.92 states that if a client makes a serious threat of physical violence against a reasonably identifiable victim or victims, and then the therapist makes reasonable efforts to communicate the threat to the victim or victims and to a law enforcement agency, then the therapist is immune from liability. Furthermore, the RBT Compliance Code provides additional guidelines. Section 7.02b states that if there is the potential for harm, technicians must take the necessary action to protect the client, including, but not limited to, contacting relevant authorities, following organizational policies, consulting with appropriate professionals, and documenting efforts to address the matter. So here is quiz question number 7. Which statement below best represents an example of a zero-tolerance policy? A. Employees may never abuse or neglect a client. B. Employees may occasionally yell at a client if the client shows inappropriate behavior. C. Employees may sometimes hit a client if the client hits the employee first. Or D. All of the above. That's right. A. The statement that best represents an example of a zero-tolerance policy is that employees may never abuse or neglect a client. Now let's go over the mandated abuse and neglect reporting laws. Typically, all clinical employees are mandated reporters and must comply with the reporting laws at all times. This includes trainees, behavior technicians, senior behavior technicians, assistant case managers, behavior supervisors, assistant clinical directors, senior clinical directors, executive director, etc. So what are the mandated reporting requirements? Well, a mandated reporter shall make a report to an agency, such as Child Protective Services, whenever the mandated reporter, in his or her professional capacity or within the scope of his or her employment, has knowledge of or observes a child whom the mandated reporter knows or reasonably suspects has been the victim of child abuse or neglect. We have highlighted the words knows or reasonably suspects, and we will go over the definition of reasonable suspicion next. A report is required when a mandated reporter has, based upon facts that could cause a reasonable person in a like position, drawing, when appropriate, on his or her training and experience, reasonable suspicion of child abuse or neglect. Reasonable suspicion does not require certainty that the child abuse or neglect has occurred, nor does it require a specific medical indication of child abuse or neglect. Any reasonable suspicion is sufficient. Okay, it's time for quiz question number 8. When should a mandated reporter make a report to CPS? A. If he or she observed a child being abused. B. If he or she reasonably suspects a child is being abused. C. If he or she imagined a child being abused. Or D. Both A and B. Yes, the answer is D. Both A and B. So let's review the process for reporting with regard to the legal requirements. Specifically, all suspected abuse or neglect must be reported to the applicable governmental authorities immediately, or as soon as practically possible, by telephone. Please see the CPS emergency numbers for California in the training resources. Also, a written report must be prepared and sent by fax or electronic transmit within 36 hours. Also, please see the written Suspected Child Abuse and Neglect form provided as a resource. Additionally, in Los Angeles County, a written report can be made via their website, which is dcfs.lacounty.gov/contactus/childabuse.html. In addition to the legal reporting requirements, many organizations have a process for reporting. First, employees should inform their supervisor of the suspected abuse or neglect immediately or as soon as practically possible. Then, the supervisor can make the report on behalf of the employee, or he or she can request that the employee make the report. Either way, the CPS report must be made within the legal timelines by one of the informed staff members. If the supervisor is not available for some reason, then the employee is still responsible for making the CPS report. If you have a large organization, you can typically call your office and get a backup supervisor to assist you. However, in the small chance that the employee cannot get a hold of a supervisor, then it is still the employee's responsibility to report. Finally, as within 24 hours, employees should complete any Special Incident Reports, or SIRs, for the organization. Please see the sample Special Incident Report form in the training resources. It's time for quiz question number 9. When should a written report be submitted to CPS by? Is it A, within 12 hours, B, within 24 hours, C, within 36 hours, or D, within 48 hours? You got it. The answer is C. A written report should be submitted to CPS within 36 hours. Now let's go over the consequences for failing to follow the law. A mandated reporter who fails to report is guilty of a misdemeanor punishable by 6 months in jail, a fine of $1,000, or both. Also, employees who fail to report within appropriate timelines may be subject to disciplinary action by their organization. Lastly, let's discuss the concepts of confidentiality and immunity from liability. Basically, although you must give your name when you make a report, your identity and the content of the report shall be confidential and only disclosed to those agencies who receive or investigate the report. In some cases, the reporting employee and the organization will make the decision to tell the family about their report. However, the employee is allowed to request anonymity. Furthermore, at the request of the employee, the organization may remove the reporting employee from the client's case. Also, mandated reporters are provided immunity from civil and criminal liability for making required reports. We have made it to our last quiz question, number 10. True or false? Child Protective Services will tell the parent that you reported him or her for child abuse after you make a mandated report. A, true, or B, false? You got it. The correct answer is B, false. CPS will not inform the parent that you reported them for child abuse. This brings us to the end of the abuse and neglect training. We hope you have come to recognize that clients with autism and other disabilities are vulnerable to abuse and neglect. That is why it is so important to recognize the signs of abuse and neglect so that you can make reports if necessary. Finally, employees should take seriously the zero-tolerance policy of their organization, as well as mandated reporting laws, in order to protect all involved. Thank you for your participation in this training. Please ensure that you have signed the Acknowledgement of Mandated Reporter Training and the Zero-Tolerance Policy for Abuse and Neglect forms for your organization, if applicable. Let's all work together to stop child and elder abuse and neglect. This training was designed by Helen Motter, a board-certified behavior analyst, and Corrine Pilkington, a board-certified behavior analyst and licensed marriage and family therapist. This training program was designed to meet the training requirements for the following credentials or certifications: the Registered Behavior Technician, or RBT, the Board-Certified Autism Technician, or BCAT, and the Applied Behavior Analysis Technician, or ABAT. The RBT task list items covered in this training include Section E, Documentation and Reporting, specifically E-04, comply with applicable legal, regulatory, and workplace reporting requirements, as well as sections from the Behavior Analyst Certification Board's, BACB's, Professional and Ethical Compliance Code for Behavior Analysts, or the Compliance Code, Section 7.02, Ethical Violations of Others and Risk of Harm, and 9.01, Conforming with Laws and Regulations. Furthermore, this training covers the Board-Certified Autism Technician, or BCAT, Task List Standard F, Ethical and Legal Issues, specifically Section F-4, Recognition of Client Abuse, and Section F-5, Reporting Client Abuse. This training also covered the BCAT Code of Ethics, Section 1, Legal Requirements, specifically Area 1-1, Adhere to all laws, regulations, policies, and ethical standards that apply to the practice of providing applied behavior analysis. Finally, this training covered the Applied Behavior Analyst Technician, or ABAT, Task List Standard 14, Legal and Ethical Considerations. Specifically, Section 14.8, explain the ABAT's obligation in regard to reporting suspected or known child and dependent adult abuse or neglect, and Section 14.9, define and compare the duty to warn and the duty to protect. Also, this training covered the responsible conduct of ABAT and QASP Area 2, the ABAT and QASP's responsibility to individuals, Section 2.2, obligations as a mandated reporter as follows. ABATs and QASPs will be familiar with applicable state and federal reporting requirements in regard to reporting suspected or known child, elder adult, and dependent adult abuse or neglect. References used in this training include the California Civil Code, Section 43.92, the California Penal Code, Section 11164 through 11174.4, the California Welfare and Institutions Code, Section 15600 through 15675, the Child Abuse Prevention Handbook released in 2006, the Child Welfare Information Gateway from 2013, and an article by Granich from 2012 called Duty to Warn, Duty to Protect. Resources provided with this training include Child Protective Services Emergency Numbers for California, a sample special incident report, a suspected child abuse and neglect form, and a zero-tolerance policy for abuse and neglect. Thank you for participating in this training program. Please feel free to access the printable resources and/or examination that accompany this training.